Today, we're tackling something that drives so many parents absolutely crazy. We're talking about that collision, that crash between the world of therapy and the world of family court.
So let me guess, if you're going through a tough custody case, you've probably found yourself asking this exact question. You're thinking, wait a minute, my child's therapist knows them. They see what's happening. Why on earth won't they just get involved? Just write a letter or testify. I get it. It can feel like they just don't care or they're not on your side. But trust me, the reality is, it's way more complicated than that. So let's actually break down why this happens and, more importantly, what you can actually do about it.
And this right here, this really gets to the heart of the problem. You've got to understand, therapy and court are basically two different worlds. They operate in completely different universes. I mean, think about it. Therapy, that's a private, safe, supportive space. Its whole goal is healing. And then you have court. It's public, it's adversarial, and its goal is just about finding facts about winning and losing. So trying to smash these two together? Yeah, it's a lot like trying to mix oil and water. They don't mix because their goals are literally the opposite of each other.
Okay, so what's the number one reason for all this friction? It really just boils down to a huge misunderstanding of what a therapist's job actually is. The legal system, a lot of the time, tries to jam a therapist into a role they were never, ever hired for, and in fact, a role they're ethically not allowed to take on.
So let's be super clear about this. A treating therapist, their job is to be an ally. Their one and only client is your child. Their entire world revolves around giving that child care and support in a totally safe, totally confidential space. Their loyalty isn't to you, it's not to the other parent, it's not to winning a court case, it's to the healing process, period.
Now, flip that coin over and look at a forensic expert. This is where it gets really different. A forensics expert's client? You could say it's the court itself. Their job has nothing to do with care or healing. Nope. They are a neutral investigator. They're the ones who are supposed to interview everybody, dig through all the data, and then give the court an objective opinion to answer a very specific legal question.
So you see the problem, right? A therapist's role is to heal, not to be a detective. So they simply can't answer those big, heavy legal questions you see here. Think about it from their perspective. They've only ever heard one side of the story, your child. They haven't read police reports or sifted through school records. For them to suddenly offer an opinion on who the better parent is, it would completely shatter the trust they've worked so hard to build with your child. It's a non-starter.
But it's not just about getting the roles mixed up. It goes deeper than that. Dragging a therapist into a courtroom, well, that actively puts the entire therapy process at risk. The child's healing itself is suddenly on the line.
I mean, just put yourself in your child's shoes for a second. Could you truly open up and be vulnerable with a therapist if you thought every word you said might end up being read out loud in court? No way. Confidentiality is the absolute engine of therapy. The second a kid, or anyone really, starts thinking their private thoughts could become public ammunition in a fight between their parents, that's it. They shut down. The therapy, the healing, it just stops, dead in its tracks.
Okay, this is another one that trips people up all the time, the subpoena. A parent will have their lawyer fire off a subpoena, and they expect to have the therapist's entire file on their desk by, tomorrow morning. But here's the thing you have to understand. A subpoena from a lawyer is not the same thing as a direct order from a judge. The therapist has a primary duty ethically and legally to protect their client's privacy. They can't just hand things over. They have to wait for either the client's okay or a real direct court order before they can release a single piece of paper. And believe me, the risks don't stop there. Oh no. In these really high-conflict cases, therapists can quickly become a target. Suddenly they're being accused of bias, they're getting dragged into board complaints, it's a nightmare. And the professional ethics codes, they're crystal clear on this. They warn therapists, do not get caught in the dual role trap of trying to be both a supportive therapist and a neutral evaluator. It's a massive conflict of interest, and it ends up hurting everybody.
Okay. Wow. So that's the problem. And it's a big one. But let's not just dwell on the negative. What's the solution here? Well, the good news is, there is a way to get genuinely helpful information from a therapist without completely blowing up the therapy in the process. It all comes down to knowing what you can and what you absolutely can't ask for.
Think of this chart as your cheat sheet, your roadmap. Over here on the left, these are the reasonable asks, the yes column. Things like, can you just verify that my child is in treatment? Or can you provide a general summary of their progress? Simple facts. But over here on the right, these are the big no's. This is the danger zone. Asking for custody recommendations, diagnosing people they've never even met, or weighing in on heavy issues like alienation, that's just not their job.
So the whole game really comes down to this: how you frame your request. There's actually a formula for it, a way to ask that respects their boundaries and makes it a whole lot more likely that you're going to get a yes instead of a no.
And here it is. This is the magic formula. You need to ask for what's called a scope-limited summary, something that keeps them firmly inside their role as a treating therapist. And here's the absolute key. You have to explicitly say out loud, I am not asking you for a custody recommendation. I am not asking for your opinion on the other parent. When you say those words, it's like a signal to the therapist. It tells them, okay, this person gets it. They respect my boundaries. And that makes them so much more willing to cooperate.
And check this out. This is literally the key to the whole thing. Just look at that email subject line. Limited treatment summary request, no custody opinion. Boom. Right away, the therapist sees that and knows this is a safe request. They can breathe a sigh of relief. And then the rest of the message just lays out those points we just talked about. It makes it so easy for them to say yes and help you out in a way that's totally ethical.
So when you boil it all down, it's this simple. If you need the facts about your child's therapy, what they're working on, their clinical needs, then you go to the treating therapist. But you have to use that right ask we just covered. But if you need an opinion on custody to present to a judge, you need a totally different person. You need a neutral forensic evaluator. It's all about using the right tool for the right job.
And that really leaves us with the single most important question you can ask yourself in all of this. In the middle of this stressful, all-consuming quest to win a legal fight, you have to take a breath and ask yourself this: is my legal strategy protecting my child's healing, or is it accidentally destroying it? The answer to that question, well, that could change everything.